There are clauses in contracts that everyone should be mindful of and pay attention to when they enter. An example of one that I bring to my client's attention is a paid when paid clause. Those types of clauses allow typically a general contractor to stiff a subcontractor. If the general contractor doesn't get paid by the owner, they have no obligation to have to pay the subcontractor. Sometimes these contracts are enforceable, sometimes they're not. Being aware of them in advance of whether it's enforceable or not can tell the subcontractor whether he needs to either not sign the contract or adjust his price to account for the risk that the contractor may get stiffed. So it's important to be aware of those types of clauses. Another type of clause that we often see in contracts are things referred to as indemnity clauses. And that's where one party agrees to pay for what another party may be required to pay to a third party, including the indemnified party's attorney's fees and costs and things of that nature. Very important to be aware of that, because if you're in agreement to indemnify somebody, it could have big implications for your business. One, you could choose, if this is something someone's asking you to sign, you can say, I'm not going to sign this because it's asking you to do too much. If you do agree to sign it, you could also get insurance that helps protect you and the party you've agreed to indemnify. So being aware of this is very, very important so that you can plan and adjust your business accordingly. Another type of clause that we often see in contracts is what's referred to as an arbitration clause. And what that clause does is that the parties have agreed that if there's a dispute that arises under this contract, that instead of going to court to have a judge or jury decide how that dispute gets determined, they agree to go through a process called arbitration, where the parties pay for typically a lawyer or some other expert to review the case and make a decision on how it turns out. The purpose of arbitration clauses is supposedly to make the expense of resolving the dispute be lessened. However, sometimes the arbitration clauses require you to go to other states, hire lawyers in other states, and pay very expensive fees to arbitration companies to get disputes resolved. So sometimes they have the opposite effect of the goal of reducing expenses for disputes. So it's very important that you have these things analyzed very carefully and you have a full understanding what your risk and exposures are before you enter any type of arbitration clause. If you have a contract that you want reviewed or assistance drafting, we can help you at Venezia Associates look for these types of clauses and many, many others to give you advice so that you can plan accordingly in your business endeavors.